Hello, everybody. My name is Maxime Turcotte. I'm a partner at Stikeman in a corporate group. And today we're going to spend a bit of time talking about hybrid private M&A transactions. So it's not a very common type of transaction, and we thought it would be useful to spend some time on it. Really a mix between public and private M&A deals. And there's some special features of those transactions that are, at least I think, are interesting to talk about. Throughout the presentations, if you have any questions, feel free to type in your questions in Zoom. So we'll try to answer them as best as I can, but it can be dynamic, or at the end of the presentation, I'll leave 5 minutes for questions also. So to start with, what is a hybrid transaction? So very simply, it is a transaction that involves a company that is not a public company, so it's not listed, it's not a reporting issuer, but at the same time, it has a widely held base of shareholders. So there's no hard and fast rule, but at least over 100 and up to 3,000, 4,000 shareholders. So these companies are not common, but when you are involved in an M&A transaction involving a company like that, it presents special type of challenges. Oftentimes, these companies are employee-owned. That is, the employees are shareholders and also notionally are composing the board. And then it's often in those contexts that when shares are issued to employees, but the company remains private, you could end up in a situation where we have a very large base of shareholders, but the company remains private. So today I'll spend a bit of time on the key aspects of an M&A transaction involving a company like that. It will be both from the perspective of the target or the seller and of the buyer. So I won't make a big difference. I think these things need to be figured out for both parties as you navigate through a transaction. So the first step in looking at a transaction with an hybrid company is really structuring. So oftentimes, companies will spend a large amount of time figuring out their shareholder agreement and what kind of governance they have, what kind of exit they have. And you would encounter these companies where they really expect that they have sort of a mechanism in their shareholder agreement that allows them to initiate a strategic process or sell the company and do it efficiently within the bounds of the shareholder agreement. It's often the case that that agreement has been shared with all the partners. There's a reasonable expectation on the part of the shareholders that that will be the way to go if anything happens, and that's what they've been explained in the various documentation that they have signed. So the other logic is typically those companies are employee-owned and they don't necessarily do M&A as their main job. So you do have to have a conversation about structure. The challenge with the shareholder agreement is that it never provides, in the context of a sale, 100% certainty on the ownership of shares. So you may have a drag, or you may have a provision that allows you to privatize the company or own 100% or proceed with a merger, but you just need one shareholder to say, look, I don't agree, I'm hiring counsel, I'm going to contest this in court. And then you have uncertainty as to whether or not you own 100% of the shares on closing. Obviously, if you get everybody to sign an agreement, that solves the issue. But the whole challenge about hybrid transaction is that there's too many shareholders for you to take that risk. You would not want one or handful of shareholders to hold up a transaction. And also, like I just mentioned, the shareholder agreement is likely creates some moderate level of uncertainty as your ability to own 100%. The other key aspect is that most of these transactions are financed. So your lenders for the transaction is really important for them that you own 100%. So you could fully consolidate. You don't have to deal with minority interest. You have full control. There's no litigation. There's no issue. So they really want certainty. So between all of those considerations, we typically end up doing plans of arrangement for these types of transactions. In corporate law, when we're stuck, we do a plan. It's pretty much the answer. So it is very similar to a public plan of arrangement. So it's the same steps. And the plan of arrangement gives you 100% certainty on the ownership of the target share on closing. It is a statutory process. As you may know, between 80 and 90% of public company transactions are operated through a plan of arrangement. So we use the same sort of recipe to a private deal. Now, depending on the size of the deal, that process is a little bit more expensive because you have the court process. There's a bit more paperwork to prepare and opportunities for shareholders to contest, but it is the preferred route for these types of transactions. There may be others. It's not impossible to do a merger, but it's not necessarily the preferred route or the most common used route for these types of deals. Just to recap on the steps of the plan of arrangement, very simply, the first step is after you sign the agreement with the target, you need to go to court to get an interim order. The courts, in our experience, even if it's a private company, are very open to doing plan of arrangement for these types of deals. Then you do need to prepare a circular that you send to your shareholders. The circular is not quite the same as a circular for a public company deal because you don't have the same of the form requirements, but you do need to provide all material information for your shareholders, which ends up in substance being very close to a public company deal circular. Then you have a shareholder meeting, which is usually based on obviously corporate law. And in a private company context, you would also look at the shareholder agreement to make sure that if there's a supermajority threshold, for instance, you probably inspire yourself with that because the judge at the end of the day and the shareholders expect that the shareholder agreement will be complied with. So you would look to incorporate those rules in your plan of arrangement as much as you can. And then you have the final order where the judge opines on the fairness of the transaction. It does give rise to the ability of or opportunity for certain shareholders to show up and complain. In our experience, that really happens. Most of these companies are, yes, widely held, but they're mostly employee owned, and it's very unsettling, difficult for a shareholder to litigate in these circumstances, especially short of court. So show up at court. So that rarely happens, similarly to a public deal. The last point I think that's important in plan of arrangement is, and as we will discuss a bit later, the hybrid deals give rise to the challenge of out-enforcement provisions because not all shareholders will sign up to the agreement to sell. Obviously, in the public company context, the only thing the shareholder gets is the consideration. So either cash or stock or a mix, and they sign a very simple letter of transmittal to get that consideration. In the private company context, you have a bit more requirements sometimes on the part of the buyer. Maybe they'll ask for an indemnity, maybe they'll ask for non-competes, maybe they'll ask for other agreements that are ancillary to the main transaction. And then the plan of arrangement is used to sort of put forward the best mechanism to enforce those side agreements as part of the transaction. Not all of those strategies have been tested in court, but generally practitioners feel very comfortable that we would get, like, for instance, an indemnity being forcible if it's part of the plan and clearly explained. So the plan gives you a bit more flexibility on those things that are challenging, would be otherwise challenging. Okay, I'll very briefly talk about tax. Not my area of expertise, but I'll try to repeat what I've been told. But the rules and the main considerations for the transaction on the tax front are the same as in any other private transaction. And the plan of arrangement helps you achieve those objectives. So firstly, in a deal like this one, you would look to expense your counsel fees and investment banking fees. And the plan of arrangement gives you a bit more of a better argument that the company can deduct those fees as opposed to the shareholders themselves, which can become challenging. It's not a certainty, but the plan is a bit more favorable on that front. You always have, obviously, the lifetime capital gains exemption that shareholders will want to use. And especially in the private context, most of the targets are Canadian controlled and private companies, so they benefit from that lifetime capital gains exemption. And that's a key part of structuring the transaction from a tax point of view. If there is a rollover component, that is, some of the shareholders receive a stock consideration as part of the deal, then you would be able to roll over. That is, defer the tax until the later sale. If the buyer is a US or non-resident, then it gets a bit more complicated because the rollover is not necessarily available unless you do a more complex exchangeable share structure. So it can be done, but it creates a bit more complexity. So in short, the tax considerations are very similar to any private deal. And the plan of arrangement allows you to have the same benefits for shareholders, maybe a bit more for advisor fees and deductibility. So now we get to the crux of the matter, which is quite sort of interesting on the hybrid deal, is the board process. So at a very high level, yes, we are dealing with a private company that's not listed, so you don't have to comply with securities laws, but that does not take away from the fact that the board of directors of that company has the same fiduciary duties as a public company. The structure of the board will oftentimes be very different than public company, and just to make the distinction, a public company in most instances would have, passive financial shareholders that are not involved in the company, professional directors that are managing a widely held company, and management who's named by the board of directors. So you do have, in that scenario, a particular set of interests, and the directors will, in the context of a transaction of a public company, make a number of decisions on behalf of shareholders without the consent. Do we engage in a process? Do we sign an agreement? Do we propose a transaction to our shareholders? So it creates sort of a situation where you have a textbook approach to these types of transaction. A financial advisor, a special committee, and the special committee is meant to deal with the sort of latent conflict of interest that could happen between the interests of management, who may not be incentivized necessarily to sell, or may have different interests than the shareholders, and the board that's trying to sort of act on behalf of shareholders, but has to consider the interests of management, the rest of the employees, and et cetera. So that's a sort of a setup that's known, and there's sort of a textbook approach to it, and practitioners know how to act. In a hybrid context, you have some of the same features. So you do have a wildly held base of shareholders that you can't necessarily consult for you to go forward and say, I'm going to initiate a process to sell a company, I'm going to merge or do a transaction. So you don't necessarily have the ability to consult your shareholders. You are taking a number of decisions on their behalf without their knowledge and consent at certain stages. The big difference is oftentimes these companies are employee owned, which means that your board of directors is composed of people who are employees, shareholders, and directors, as opposed to a public company where you've separated the roles of management, board, shareholders. All those roles are now in one body, which is the board. So although you do need a strong board process, you would get a financial advisor, ideally external counsel, to do it. It's not clear that you need a special committee, because it's not clear that you have the same latent conflict of interest, or if you do have a special committee, then who sits in that committee? How does it work? Who is more independent than somebody else? So there's really a conversation to have at the board there in terms of the governance that's required for a deal like this, because you do have the same features as a public company, although not quite. And you can't just apply the same logic necessarily, and that has to make sense. Most companies who do this will hire a financial advisor and will get a fairness opinion. A couple of reasons. First, they're not professional M&A practitioners, so it's helpful for them to get the advice of an expert on whether or not they're getting the best value for their company. They will need to make a recommendation to their shareholders as to the transaction at some point, and that fairness opinion helps them do that. And it also helps with the fairness hearing as part of the plan of arrangement, because as you may know, the fairness opinion is one of the key features that the judge will look at to approve the transaction. One last thing that boards cannot forget when they consider a transaction like this is, like a public company, they will send a document to their shareholders explaining what they've done, the process they've ran, and the results that they are proposing to shareholders in the transaction. And that will be included in sort of a background to the offer. And it's very comparable to a public company. You would explain how many bidders you spoke to, or maybe it was a bilateral conversation with one bidder, the prices offered, the consideration, the type of advice you got. So you'll need to tell your story to shareholders the same way a public board does. So it's important to keep a good record of what you've done, have good minutes, have a strong process, because you'll go through the same sort of disclosure process that you would do in a public company. One key challenge for these types of deals is how you deal with employee shareholders. So the big feature of a private company that has a number of shareholders that are employees is that you effectively tell your shareholders, you are owners. We are partners together, you own shares. It's not only, yes, a financial incentive, but it's also a sort of psychological incentive to be part of the business in which you're an owner and you have a say on the direction of the business. So that's the sort of generally the expectation of the shareholders and the employee shareholders that are part of your wildly held group. So you've told them your owners, we're going to do this together, and you have regular meetings and information. And what happens is then the board is either faced with a transaction or faced with an opportunity to run a process or look for a partner. And they wonder, well, when do we tell our shareholders? What do we tell them? How do we engage with them? And you really have to balance in those scenarios the need for transparency on one hand. You would want your shareholders to know, you would want them to feel engaged and as owners. On the flip side, you're really worried about leaks, and you're really worried about everybody knowing and the public knowing, and then the transaction being sort of in jeopardy because there's been a leak about the transaction, or some of your other employees that are not partners have wind of the transaction. Then you run into retention issues. People are saying, well, if there's a transaction, maybe that means I'm going to lose my position. There's going to be some synergies, et cetera, et cetera. Well, so obviously a big M&A transaction creates uncertainty. So this sort of creates something that's a bit different than your normal transaction, because your shareholders are your employees, and you need to manage that appropriately while maintaining certainty of the transaction and not having leaks that would endanger the transaction. So every situation is different. I've seen many ways to do it. Every transaction has sort of operated differently. So I've seen transactions where targets had provided in the shareholders agreement a very clear path in order to do a change of control transaction. So they needed to get to a certain threshold and certain board approvals and certain engagement to get a mandate to initiate a process, at which time then with bids they would go back to shareholders with certain information. So that's all good when your shareholder agreement already has a path forward, so the board has the comfort that they can act in accordance with that recipe and move forward. Most times that's not the case. The shareholder agreement of the company will not have all those bells and whistles, so you need to figure out what's appropriate. And I've seen a couple ways that you could do it. I've seen sort of stepped engagement where the board would reach out to shareholders and, without naming anybody's particularly or any type of process or any bidder or any counterparty, would say, to shareholders, would you consider, initiating a strategic review, or they give us the mandate to look into those things. So at least without the shareholders having detailed information about any prospective purchaser or partner, they would give the mandate to the board to sort of engage and see what kind of partnership or purchaser they can obtain. I've also seen it to be done in a very traditional way, where the board will take on themselves to, unanimously make a decision that this is the time to either sell the company or find a partner. They will run a process, and once the deal is signed and announced, then you would engage shareholders, announce a transaction, and sort of really convince them that this is the best thing for the company. Obviously, you would expect your board to have enough of a stake in terms of share ownership to be a good proxy that a transaction is good for the company. And the more the share ownership is strong at the board level, the better position you're in to play the more traditional approach, where you sign and announce after to your shareholders, and they're not necessarily aware of anything before you sign all the documentation. Okay, now we get to deal terms and the special challenges that we have in a hybrid deal. So the couple of features before we get to the terms are the following. So you oftentimes have shareholders that have a small interest in a company. So yes, it's significant in terms of their personal wealth, but it's not dissimilar to a public company situation where they have a small stake in the company. They're not necessarily involved and have visibility in all the operations. It would be an employee situation where the person is responsible for a certain division, a certain geography, has shares. They understand their world very well, and they manage their practice or business or division very well, but they don't have the visibility on the overall business of the company. So not able, for instance, to provide reps and warranties on the overall company. They don't have the knowledge or the ability to take on that risk. Those shareholders are really looking for certainty. So when they're told, look, we'll sell the company, they really want to know what price they're going to get, and any indemnity or adjustments would sort of take away from that certainty, and that's not necessarily ideal for them. And lastly, the worst thing that can happen to small shareholders is the risk of being joint and several. That is, being on the hook with all the other shareholders as vendors. Sometimes that happens in private companies, where all the shareholders are joint and several for the indemnity of the transaction. That'd be a disaster for a small shareholder. You can imagine somebody has 1%, 2% of the company could be liable for for the whole indemnity package of the company. So all those features make it challenging to apply a private company construct to a hybrid deal. And a private company construct would be a typical purchase price adjustment, either working cap, debt, and there's others. Also an indemnity cap package. You could look at rep and warranty insurance, but definitely you would have indemnities, surviving obligations, covenant, et cetera, et cetera, et cetera. So for the shareholder, that's really challenging to get that. On the flip side, the purchaser doesn't have the comfort of a public company. And the reasons why public company deals are structured the way they are is, a couple of reasons. First, you can get shareholders to sign up, and they can be on the hook for indemnities. They will get their money, and that's it. So you have to rely on the company, and there's never post-closing indemnity. But the flip side of that is you have the history of a public company. You have a company that's been audited, financial statements are published, there's disclosure with the company, there's a board of directors that has securities liability if they don't provide proper information to the market. So all this package of regulation together ensure that the bidder has a certain level of comfort on the public company that is looking to buy. And also the limited diligence that is often done on public companies, which is more targeted and relies on public information and in a large part. So now we have none of those advantages. Private company, no public disclosure, no scrutiny of the public markets, but also shareholders that are worried about their personal liability and want the same deal that a public company shareholder would get. So you're sort of in the middle, and it creates sort of a distortion between what the purchaser needs to protect their interests and what the shareholders are willing to give. and sort of the challenge of these types of transactions in terms of the deal terms. So the first one is the indemnity. Can you, in a deal like that, where shareholders do not sign up to the deal because we're doing a plan of arrangement, can you provide for an enforceable indemnity against shareholders? The answer is yes, most likely. The case law on it is favorable to that conclusion. And in order to get there, you need to demonstrate that the rep package is part of the consideration that the shareholder is getting, first, and second, that consideration is can be determined by the shareholder. So if you do want to do an indemnity, you would say to your shareholders, look, we've given reps on your behalf. There's an escrow that guarantees those reps and warranties. And if for whatever reason there was a breach, then we'll take against the escrow, and then they're capped to that escrow. So you can say to shareholders, the worst case is this is the amount you're going to get if there's a claim. So the shareholder can determine the amount and part of the consideration that they're getting. The flip side is you cannot give all the consideration upfront to your shareholders. The shareholders, as I said before, are really not in a position to determine whether or not those reps are true. They haven't been part of the diligence. So it's really sort of relying on somebody else to determine whether or not they're going to get their full consideration. And it creates uncertainty as to what they're going to get. So it's not necessarily the preferred route. So oftentimes in these types of transactions, especially last 10 years, rep and warranty insurance is almost prevalent. You would look to go to a rep and warranty insurer and insure the risk of the rep and price that into the transaction, such that the purchaser has a recourse against insurance and the shareholders are sort of free with their money and they'll not have to worry about an indemnity claim. By the same token, you would want the reps to not survive closing and the purchaser as only the insurer to look after. Another topic that comes up often is the purchase price adjustments. So again, making the distinction with a public company where the company is under scrutiny. There's sort of a natural lockbox in the public company where you have to declare dividends. You would have to make an announcement, and you could easily sort of control that as a purchaser. So the public company context creates a situation where there's no purchase price adjustment, or very, very rarely. You can do them, but they're very rare. And then we migrate to the private company context where you want to give certainty to your shareholders. You want to say you will get, let's say, $25 a share. And that amount, you don't want it to move because the working cap's not as high, or the receivables or the debt has increased. So it creates a challenge. Because again, being a private company, the purchaser would want to have a normalized level of working cap or any other adjustment they're looking for, versus the shareholder wants certainty. So that's really a question of comfort between the purchaser, the way the business is run, and it really depends on the industry. Obviously, if it's an industry where there's high cyclical movements of working cap over the year, then there may be less ability to do that. But if it's stable and you're conservative enough, maybe that purchaser would be able to say, look, I won't do any purchase price adjustment as long as you have sort of a lockbox, which means you won't distribute any funds to your shareholders, no dividends, no special payments, no special bonuses. If you don't do that, then we'll pay you a fixed price based on a historical balance sheet, and we'll leave it to that. So that gives certainty to your shareholders. So that's achievable. You could also do a purchase price adjustment mechanism that's more typical, but then you need to say to your shareholders, as part of your approval, consider that you may get 25 or 23.5 or maybe 26, and then that consideration is variable based on a working cap, and it makes the disclosure to shareholders and the vote a bit more complex. You have to create these bands and make your shareholders comfortable that they're going to get certain value. Let's talk about a little bit about the fiduciary out. So the public company, it's very typical to once you sign the agreement, the board always retains the ability to recommend a superior proposal to the initial deal that's been signed up and recommend it to shareholders. And that's in 99.9% of transaction, and subject to the payment of a break fee, you're able to change your recommendation and go with another deal. Now, in a private company context, you have some of the similar features in the sense that your board, having a widely held base of shareholders, has signed up to a transaction and then is recommended a transaction, but shareholders have to vote on it. And somebody could come as an interloper and say, look, I'm willing to offer more, and I want you to terminate this first deal and go with the second one. So in corporate law, we always sort of have this debate as to whether or not a fiduciary out is technically strictly required under Canadian corporate law. That is, could a board actually say, I'm making my bet with this bidder and I cannot change my recommendation? And there's some support for that notion that you probably could. It's definitely not the practice, but that conversation becomes a bit more under pressure in a private deal, where the bidder comes at it from the view of like, this is a private company. I'm not really interested in an interloper. And I want to have certainty of transaction, I have certainty of closing. I don't want to have you do the ability to change your recommendation. So in most of the transactions that we do on the hybrid basis, there is we try to maintain the ability of the board to change the recommendation to a certain extent, but you really have the whole full fiduciary mechanism that you typically have in a public deal. It is usually simplified, it's really restricted, and a couple of reasons for that. First is, in practice, it would be very hard for an interloper to jump in because the information is not public. And it's not clear how you would make your sort of agreement with the first bidder public. So in the public company context, the second, the interloper relies on the public information to make a better offer. In a private company context, you don't have much. So it's very hard to actually see how an interloper could successfully break up a first deal because of the lack of information. The other thing is, especially in an employee-centric world, yes, there's value that's important, but when you sell your transaction to your shareholders in the hybrid deal, you sell them, the opportunity of employment as well. And that's a key feature of your transaction because they're usually employee-owned businesses, and your employees will rely, yes, on the money they're getting for their shares, but also what kind of position they'll have, what's the story going forward. And it's not clear necessarily that an interloper can offer the same comfort or same vision on the employment front. So as usually an advisor to the board, we're a little less stressed about the fiduciary out, and we give in usually on a very minimal package that allows you to change your recommendation in very limited circumstances. That just maintains your fiduciary obligations, and we don't cross any red lines on corporate law, but it's really not the full package. And in as much as you can, you would use lockups with your key shareholders to protect your board. So for instance, if you have 20, 30, 40% of your shareholders that are concentrated, let's say at the board level, or the board and a very subset of shareholders around the board, then you could get comfortable on the Schneider doctrine that the board is protected by the fact that certain shareholders have, sort of given lockups in favor of the bidder, which would necessarily require a full fiduciary out. On financing, it's very similar to any private public deal. You would want certainty financing, and you want to say to your shareholders that the deal is fully financed and there's very little risk on that front. So I think that's one aspect where there's not much difference between private, public, and hybrid. Okay. Another topic that often comes up in these types of deals is the non-compete agreements. So when you deal with employee shareholders, the purchaser will typically want to, purchaser will typically want to ensure that shareholders who get a large consideration as part of the transaction sign up to non-compete agreements. It is often the case that these employee shareholders have accumulated a large equity stake compared to their personal wealth. And when they get to that liquidity event, they have, they're going to realize a substantial gain on their shares, especially given that lifetime capital gains exemption, the first almost $1 million is free. Purchaser will want to make sure that your employees that you're notionally purchasing are very incentivized to stay with the business and will not take their money and go somewhere else. So it is always a key objective of the purchaser to get those non-compete agreements signed. A couple of challenges there. First, not everybody's getting the same consideration. So you cannot have a cookie cutter approach where you have the same non-compete, the same timeline for all the shareholders, because although it's widely held, then you cannot ask the same duration or let's say geography for everybody. So you need to have a bespoke approach, which complexifies the situation. And the other big concern is conditionality. So your purchaser would say, like, I need, the following people or the following 50 shareholders to sign non-competes. And then as a board or as a target, you would say, well, I don't want to talk to those shareholders before we announce or we sign an agreement. So, and then the purchaser will say, well, it needs to be a condition of the transaction that they sign non-competes. So you have this difficult conversation where you don't want to talk to those shareholders before you announce. And on the flip side is you don't want to create a condition of the transaction related to non-competes, because then it gives a substantial amount of leverage to those shareholders to sort of say, no, I'm not signing, or I'm not going forward with this, and it's not interest me. So you don't want to create a condition. On the flip side, you don't want to talk to them before. So it's not an obvious scenario. And that's in sort of in theory. Now in practice, especially with employee-owned business, people don't put enough sort of weight on the notion that in these types of partnerships, when the leadership is aligned, when the leadership of the company, of the target, sort of as a story to tell, and everybody's signing up to the same documents, it is very difficult for an employee partner not to go along. It creates this notion of exclusion, of not being part of the team. So in our experience, whether it be non-compete, whether it be voting agreement, whether it be any other ancillary agreement that needs to be signed to get the deal done, where technically somebody could say, I'm not happy and complaining and not signing, and they would have a certain amount of leverage to just create some issues, it doesn't happen. Because if you actually do that, then everybody knows that you're doing it, and you're sort of an outcast in the employee group, and notionally what you're doing is you're not only getting a good consideration, but you're staying on with your colleagues and your partners going forward in the new story. And people don't want to be outcasts and don't want to be excluded and don't want to be viewed differently. So we get worked up about all these issues of, will they sign stuff that we haven't shared with them before, and they don't necessarily need to sign because it's non-compete and they may not want to, and we haven't shared with them before we announce, and there's no obligation for them to sign. They sign it because they want to be part of the team, and that dynamic sort of carries the day usually. There's always a few exceptions. Some shareholders will refuse, but in most cases, it is sort of a natural process where people will sign up and will go along with the process. Another feature of these transactions is oftentimes the purchaser will want the shareholders to maintain an amount of skin in the game going forward. So they will offer, a consideration in cash and a consideration in shares to ensure that go forward, the shareholder retains an interest in the business and is incentivized to grow it the same way they were before. There's also the advantage of creating this sort of employee-owner relationship where they feel engaged and part of the team. Spoke about it before, but obviously you want to ensure that the shareholders who decide to roll have the ability to roll over from a tax point of view. That is, they don't pay tax upfront on the rollover portion, and they defer that tax to the actual sale for cash later on. So that's definitely achievable. Again, unless you are a foreign purchaser, in which case foreign shares are not qualified necessarily rollover, unless you do an exchangeable structure, it can get complicated. So the challenge there is you not only need to offer a new opportunity if the purchaser already has an existing business, then you need to provide almost prospectus level disclosure about the combined business, because you're saying to your shareholders, look, you're going to get cash, you're going to get a certain amount of shares that is an interest in this new combined business that includes all of these parts. So you need to provide information to that shareholder to make an informed decision, which really increases your disclosure. So you have to think about that. Again, not something that's reviewed by the Securities Commission, and not something that needs to comply with the form requirements of the securities laws, but still it needs to include all material information about what you're proposing. So that could be quite cumbersome if you don't sort of focus it on that early enough. So that's one piece of it. The second piece of it is oftentimes you'll need, if the company stays private, that is, it's a private buying a private hybrid company, then the combined entity is private, and you'll want to have a shareholder agreement. And you want to bind your new shareholders, I mean the target shareholders, to the new agreement going forward. So there's two things there that are challenging. First, you need to negotiate the terms of your shareholder agreement so that it's appealing to your shareholders. And obviously, your current shareholders will look at their current arrangement and be used to that and understand that. So that becomes the new base case from which you start to say, like, this is what they're used to. We're going to migrate to this new shareholder agreement with this new buyer, new partner. This is what they're used to. How do we sort of figure out a way to make everybody happy? And the themes there that always come back are the same. And it's mainly, again, there's another conversation about non-compete in the shareholder agreement, but we talked about that. The main thing is liquidity. And liquidity issues for private companies is really the key features of these employee-owned businesses. In a public company context, if you want to sell your shares, you just go on the market. And there's a market for it. Hopefully, it's liquid enough for you to sell your shares in the ordinary course. In a private context, it's not as obvious because first there's tax issues. Who buys back the shares? The company? Is it sort of a structure with a third party create capital gains treatment? But mostly is somebody needs to have the cash to buy you out. Is it other shareholders and they're interested to buy you out? Do they have the liquidity to do that? Or is it the company buying you out? And does the company have restrictions? Obviously, you can imagine a scenario where 20% of the shareholders say, I'm resigning, I want my money back, buy me my shares, and then there's liquidity crunch on the company. So in a private company context, liquidity is the sort of big word and the big concept that you have to focus on to help shareholders understand what they're getting into and understand what's their liquidity going forward in the event of resignation, termination, retirement, debt, incapacity, et cetera, et cetera. So that's the theme you're going to spend a lot of time on. And then you need to take that and bring it to your shoulders and say, look, you are getting cash, you're getting shares, and this is the new deal. And, we think it's a fair deal. Now, the last piece of it is you need to make that agreement enforceable on shareholders. And the challenge there is you need to make it enforceable on somebody who's not necessarily signing the agreement or not obviously signing the agreement in the sense that you would announce a transaction and hope to get them to sign. And as with the non-compete, can create condition to close that says all the shareholders need to sign the agreement. So that's a bit more difficult. So you would typically put a step of the plan arrangement, which says that as part of the transaction, they're getting shares and they are bound by the new shareholder agreement going forward, regardless whether or not they sign it. Obviously, you would push for them to sign it because you want a clear record and it's easier to sort of enforce going forward. But you would try to do that as part of the plan and get the judge to bless that agreement and shareholders become party to that agreement so that it's enforceable going forward. Okay. Q&A communication. Again, in a public company context, you would sort of have a very tight communication plan. You probably have an analyst call. You have a Q&A in your circular. And it's very sort of, all shareholders are treated the same. It's very defined what you provide to shareholders, and they need to sort of speak to their broker, and their broker understands the lingo. And there's a whole system that ensures that shareholders are informed. Obviously, it's more simple in the sense that, you either like the price or you like the price, or whatever you're getting. In a private company context, there's a bit more to focus on. There's tax planning, there's whether or not you have a new shareholder agreement, there's whether you have an employment agreement, a non-compete. So the package of things that you have to worry about as an employee shareholder in a hybrid deal is a bit more expensive than a public deal. So that's one aspect of it. Second aspect of it is, it's honestly the case that those employees are ineptly advised all the time by either accountants, counsel, or their broker. It's a private company; they own shares, and they receive those shares as employees, so they don't necessarily have the sort of environment and advisors to help them navigate those questions. So those transactions will require a lot of hand-holding. A lot of hand-holding and a lot of Q&A's communication. So it's highly recommended, in my view, that once a transaction is announced, that you really have the counsel of the company that is doing the transaction to spend a fair amount of time with the body of shareholders. And the good thing about the Zooms and Teams that we've been using intensely the last 2 or 3 years is that those mediums help you have these sort of big sessions with a very big body of shoulders, like up to 300-400, where you could present, have Q&As, ask questions, and you solve a lot of the issues that are come up for shareholders. But it's definitely more engaged than a normal deal, more engaged than a private company or a public company, because you have a big body of shoulders that not necessarily the same level of sophistication in terms of this field of transactional work. So you need to help them along. A number of them will get their own accountants, a number of them will get their own lawyers. And the last piece of it is, in as much as you actually make things plain language and simple in the various documentation, not that our public company documentation is not, but it's written in a certain format that's meant for professional advisors, not necessarily for ultimate shareholders sometimes. And I think in a private company context, you need to migrate from that to a very simple form of communication so people understand what they're getting into. Okay, the closing. Before I finish, the last piece of this is the closing. And so again, making the difference between a private and public company. So in a public company, you have the whole payment infrastructure that's there to help you. You have the transfer agent, paying agents, and the shareholders are registered in a sort of a big system of shareholdings where money flows through the system in CDS, so that if you do a public closing, everything has been set up for that. You send your money to the transfer agent, depository will actually flow through that consideration through the system in accordance with their well-established procedures. They have well-established letter transmittal. Everything is been thought to achieve that purpose, and it's a well-oiled machine. In a private company, obviously, you would have, let's say, 6 or 7 shareholders. You have separate wire transfers. It's very bespoke. You just close on that basis. Now you get to the situation where you have, let's say, 500 shareholders. You don't necessarily have a transfer agent. The company is holding the books, holding the shares, or it's a counsel, and then you have the registry. You don't necessarily have a well-oiled machine. Yes, companies will often times retain a compensation agency or company to pay dividends on the shares and to send some money to shareholders, but it's not necessarily meant that company doesn't have the tools necessarily to take the shares back as part of the transaction, make sure that the shares are ended in the proper form with the proper representations and the proper signatures, and then give the cash back. So they don't have the ability, and the transfer agents that are typically acting on the public side are not usually acting on the private side. So you have, again, this sort of vacuum where nobody is necessarily fully equipped to act in this space. And frankly, those transactions are too rare for somebody to do that. So it's really important for the purchaser and the buyer in these established transactions to really focus on that early. So you need to work with probably a transfer agent that does work for public companies, but that has the ability to think a bit outside the box and to make sure that they figure out a good way to achieve the same results as a public company, given they're not necessarily a transfer agent, they don't hold a registry. So there's a lot more work and sort of on integrity of the process that needs to be done early. And usually get there, but it's a bit more engaged again. And you have to start earlier on that front. And if you leave it to the end, you end up with bad surprises. Okay, I think we've hit our time. Thanks a lot for everybody. And I'm going to zoom out. Thank you.